All right, this is a table of authorities. This thing is extensive and exhaustive, but I'm going to go through it anyway. It may take a few days, but everything in here has been looked up, verified. It is there. If you go look, you will find the same. So this is not conjecture. This is years and years of research, of an abundance of people putting together energy to put this together. It's roughly 95 pages long, and it is the like a first volume of a Bible of case precedent, if you will. Okay, and it's combined with Am Jurisprudence, Corpus Juris Secundum, Bovier's Law Dictionary, Anderson's Law Dictionary, Black's Law Dictionary. I mean, the list just goes on and on and on and on, okay? And I'm going to do my best to get through this whole volume that has been put together by many of people working in harmony with one another, reading case cites, and Supreme Court justices, and just all kinds of different all different kinds of aspects of the law and how they come into harmony with one thing in mind, and that is to preserve freedom, because freedom is not free. Litigants who seek to bring claims against federal officials for abuse of their authority have been confused concerning the proper way to characterize their actions and pleadings. Generally speaking, how one drafts a complaint and not what evidence is to be introduced determines whether a claim can survive as a federal cause of action. Tooley versus Moot, M-O-T-T, Supermarket Incorporated, 337 F, Superior Court, 834, Federal Supreme Court, 834, 844, DNJ, 1972. You know what? Before we start this out right. All right. As you all know, I cite a lot of cases, and it's important for everybody to understand what the numbers mean, what the letters mean, like U.S. And so we're just going to go ahead and lay it out. Reading case citations. Case name, italics with a comma after, would be like Marbury versus Madison. That's the case name. That's actually the court. It was Marbury's court versus Madison Supreme Court, all right? It was Marbury's court. He was the moving party. The court is on the four corners of the paper. And where they held the venue was the U.S. Supreme Court, all right? Volume number is the first number, 408. Then U.S. is the name of the reporter, all right? The numbers that come after, for example, 238, are the beginning pages. And then, of course, the date, 1972, in parentheses, all right? So when you're hearing me read case cites off, that's what those numbers mean. And that's to help you find what I'm talking about, all right? Above are the parts of the standard case citation. The citation tells us that a case called Furman versus Georgia was decided in 1972 and can be found in volume 408 of the United States Reports, starting on page 238. Some variations. When using a direct quote from the case, it is important to provide the specific page on which the quote is found. In that case, the citation would have the page added as follows. Furman versus Georgia, 408 U.S. 238, 240, 1972, or Furman versus Georgia, 408 U.S. at 240, 1972. Because federal appeals courts, circuit courts, are found in one of 12 different districts, the specific district is typically added as follows. Cooper versus Pate, 382 F period 2D 443, 7th Circuit Court, 1967. 94 federal district courts are spread throughout the country. There is at least one in every state, and the more populated states have as many as 4. The specific district should be identified. Hauer versus United States, 864 F period SUPP period 1019 D period COLO period 1994. Case name. There are typically 2 names for a case. Usually the first name identifies who is bringing the court action, and the second name is the person against whom action is being brought. In a criminal law case, action is almost always brought by the state, ergo people of the state, against a person, ergo Joe, as in People versus Joe or State versus Joe. However, the defendant may not always stay the same. In the Furman versus Georgia case, Furman was originally the defendant in a murder case being prosecuted in Georgia. However, Furman appealed his conviction, and in doing so, he became the person taking action against the state. Year. This is the year in which the decision was delivered by the court. It may not be, and in appellate cases probably isn't, the year in which the case was heard. Name of reporter. A reporter is a multi-volume publication where court decisions are found. The full name and abbreviations for the reporters you are most likely to encounter as undergraduates are full name, United States Reports, U.S. Type of case reported would be a United States Supreme Court or U.S. Supreme Court. Supreme Court reporter is identified as S period CT period. That's again the Supreme Court reporter is S period CT period, U.S. Supreme Court. Federal reporter first through 3rd series is F period, comma, F period 2D and F period 3D, Federal Appeals Courts. Okay. Federal Supplement, 1st and 2nd series is F period SUPP, comma, or F period SUPP2, important decisions from federal district courts. All right, so when you guys are hearing me read these citations, this is important so you know what it is, because I was presuming and assuming what this meant. I thought SUPP stood for Superior Court. It stands for Supplement, Federal Supplement, 1st and 2nd series. So it's Federal Supplement, and that is important because it's important decisions from the Federal District Court. Okay, so F period SU or F period SUPP2 stands for Federal Supplement, 1st and 2nd series, and it's important because the decisions are coming from the Federal District Court. Atlantic Reporter, California Reporter, Northeastern Reporter, Pacific Reporter, etc. are as follows. A period, comma, CAL period, RPTR period, comma, or NPEP, comma, or P. Okay, so Atlanta just is A. The California Reporter is CAL period, RPTR period, comma, and then the Northeast is N.E, comma, and then the Pacific Reporter is P period. Appellate level state court cases appear in one of the various state or regional reports. Volume numbers and beginning pages. Without knowing what volume of the report to look in and what page the case starts on, it would be very difficult to track the case down. Not impossible, however, as you can use the table of cases in digests like West United States Supreme Court Digest, or for very recent cases, U.S. Law Week. Similar digest exists for other federal and state cases. So again, I just wanted to go over that real quick because I'm getting ready to go through a bunch of cases, okay? And all these cases have been read by various people putting this together for people such as yourself. And it happens to be in my hands, and I'm going to do my duty to go through these things with you guys. Okay? Litigants who seek to bring claims against federal officials for abuse of their authority have been confused concerning the proper way to characterize their action in the pleadings. Generally speaking, how one drafts a complaint and not what evidence is to be introduced determines whether a claim can survive it as a federal cause of action. Tooley versus Mott, M-O-T-T, Supermarket, Inc., 337 F period SUPP, 834, 844 D.N.J. 1972. Subsequent cases have been held the Bivens theory of recovery applies to other claims under the various rights enumerated in the Constitution. For decisions concerning redress of the Fifth Amendment claims with the Bivens actions, see Young versus Pierce, DCTEX period 544 F period SUPP period 1010, and Eighth Amendment claims Mackey versus Indiana Hospital, DCPA 562 F period SUPP period 1251. For example, cases have held that if other theories of recovery are pleaded, a Bivens action must fail. This has forced attorneys to select whether they wish to use the Federal Torts Claim Act, Title 28 U.S.C. Code, Subsection 2679, and its strict presentment requirements and other federal law, or to rely on a Bivens theory. The complaint alleging both theories are at risk of a disposition motion. Sierra versus Pinchardo, 786 F period 2D period 237 Sixth Circuit Court. Federal employees may become personally liable for constitutional deprivation by direct participation, failure to remedy wrong after learning about it, creation of a policy or custom under which constitutional practice occur, or gross negligence is managing subordination who causes violation. Gallegos versus Haggerty, Northern District of New York, 689 F period SUPP period 93. 5. Am Jurisprudence 2D, arrest, subsection 1, page 695. To effect an arrest, there must be actual or constructive seizure or detention of the person arrested, or his voluntary submission to custody, and the restraint must be under real or pretended legal authority. 7. Corpus Juris Secundum, Volume 4, attorney and client. His first duty is to the courts and the public, not to his client, and whenever the duties to his client conflict with those he owes as an officer of the court in the administration of justice, the former must yield to the latter. The office of attorney is indispensable to the administration of justice and is intimate and peculiar in its relation to and vital to the well-being of the court. An attorney has a duty to aid the court in seeing that actions and proceedings in which he is engaged as counsel are conducted in a dignified and orderly manner, free from passion and personal animosity, and that all causes brought to an issue are tried and decided on their merits only, to aid the court. 7. Corpus Juris Secundum, subsection 2 through 3, attorney and client. And the term is synonymous with attorney. Therefore, anyone advertising himself as a lawyer holds himself out to be an attorney at law, or counselor at law. If one appears before any court in the interest of another and moves the court to action with respect to any matter before it of a legal nature, such person appears as an advocate, as that term is generally understood. The phrase "as an advocate" in a representative capacity, as used in the statute regulating the practice of law, implies a representation distinct from officer or other regular administrative corporate employee representation. In England and her colonies, A barrister is a person entitled to practice as an advocate or counsel in the superior courts. A solicitor is a person whose business it is to be employed in the care and management of suits depending in courts of chancery. In the great majority of the states of the Union where law and equity are both administered by the same court, it has naturally come about that the two offices of attorney at law and solicitor in chancery have practically been consolidated. Although in the federal equity practices the term solicitor is in general use, but in some states the office of solicitor in chancery is a distinct and separate office from that of an attorney at law. A client is one who applies to a lawyer or counselor for advice and direction in a question of law, or commits his cause to his management in prosecuting a claim or defending against a suit in a court of justice. One who retains the attorney is responsible to him for his fees, and to whom the attorney is responsible for the management of the suit. One who communicates facts to an attorney expecting professional advice. Clients are also called wards of the court in regard to their relationship with their attorney. What is a ward of a court? Ward of a court, infant and person of unsound mind, placed by the court under the care of a guardian. Davis Committee versus Lonnie, 290, Kentucky, 644, 162, S period, W period, 2D, 189, 190. Their rights must be guarded jealously. Montgomery versus Erie Railroad Company, CCANJ, 97F, 2D, 289, 292. See Guardianship, Subsection 3, See Guardianship. Subsection 3, Nature of Right to Practice. While it has been broadly stated that the right to practice law is not a natural or a constitutional right, but is in the nature of a privilege or franchise, the practice of law is not a matter of grace, but of right for one who is qualified by his learning and moral character. Library reference, attorney and clients. The right to practice law is not a natural or constitutional right, nor is it the right to practice. Section 25, ordinary proceedings, means the regular and usual mode of carry on a suit by due course of common law. Ordinary proceedings have been contrasted with summary proceedings in that ordinarily require citations and service and allow more time for the hearing of exceptions and other pleadings. The term special proceedings, as used in statutes, is a generic term for a civil remedies in courts of justice which are not ordinary actions, and has been defined as a proceeding in court which was not under common law and equity practices. Remember, the Judicature Act of 1789 is what blended, commingled equity and the civil Roman law. Either an action at law or a suit in equity, special proceedings are of statutory origin and do not proceed according to the course of common law, but give new rights and afford new remedies. Do you need to challenge jurisdiction? If pled by an attorney, because if it's pled by an attorney in if you were in propria persona, in one's own proper person, it was formerly a rule in pleading that pleas to the jurisdiction of the court must be pled in propria persona, because if pleaded by an attorney, they admitted the jurisdiction, as an attorney is an officer of the court, and he is presumed to plead after having obtained leave of court, which admits the jurisdiction. See pro se. Section 14, Corpus Juris Secundum, 426 and 430. The particular meaning of the word citizen is frequently dependent on the context in which it is found, 25, and the word must always be taken in the sense which best harmonizes it with the subject matter in which it is used. One may be considered a citizen for some purposes and not a citizen for other purposes, as for instance, for commercial purposes and not for political purposes. So a person may be a citizen in the sense that as such, he is entitled to the protections of his life, liberty, and property, even though he is not vested with the suffrage of other political rights. California Powder versus Gore, 2 District 207 P 490 57 C period A period 458. California Powder versus Gore, 2 District 207, page 490, 57, C period, A period, 458. LePenser versus Griffin, 83, SO period, 839, 146, LA, 58. New York Union Hotel Co. versus Hersey, 79, NY, 454. U.S., the Friendscraft in.C. 16 U.S. U.S. 14 3 Wheat 14 4 L period ED period 322. Murray versus the Chamering Besties 6 U.S. 64 2 Cranch 64 2 L period ED period 208. And Rieswick versus Davis 19 MD period 82. And Judd versus Lawrence 1 Cush 531. Okay, 16 Am Jurisprudence 2D, Constitutional Law, Section 70, no public policy of a state can be allowed to override the positive guarantees of the U.S. Constitution. 16 Am Jurisprudence 2D, Section 97, any constitutional provisions intended to confer a benefit should be liberally construed in favor of the clearly intended and expressly designated beneficiary. That would be all of you. Thanks for joining me. Then, a constitution should receive a literal interpretation in favor of the citizen is especially true with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to the person and property. 16 Am Jurisprudence 2D, Section 117, various facts of circumstances extrinsic to the Constitution are often resorted to by the courts to aid them and determining its meaning. As previously noted, however, such extrinsic aids may not be resorted to where the provision in the question is clear and unambiguous. In such a case, the courts must apply the term of the Constitution as written, and they are not at liberty to search for meanings beyond the instrument. 16 Am Jurisprudence 2D, Section 117, as to the construction with reference to the common law, an important canon of construction is that constitutions must be construed to refer to the common law. The common law so permitted destruction of the abatement of nuisances by summary proceedings and was never supposed that the constitutional provisions was intended to interfere with this established principle. And although there is no common law of the United States, in a sense of the national customary law, as distinguished from the common law of England, adopted in the several states, in interpreting the federal constitution, sources may still be had to the aid of the common law of England. It has been said that without reference to the common law, the language of the federal constitution would not be understood. 16 Am Jurisprudence 2D, Section 155. Since the Constitution is intended for the observance of the judiciary as well as other departments of the government, and the judges are sworn to support its provisions, the courts are not at liberty to overlook or disregard its commands or counteract evasions thereof. It is their duty in authorizing proceedings to give full effect to the existing Constitution and to obey the constitutional provisions irrespective of their opinion as to the wisdom or the desirability of such provisions and irrespective of the consequences. Thus, it is said that the court should be in our altar to enforce the provisions of the United States Constitution and the guards against their infringement by legislative fiat or otherwise. In accordance with these basic principles, the rule is fixed that the duty in the proper case to declare a law unconstitutional cannot be declined and must be performed in accordance with the delivered judgment of the tribunal before which the validity of the enactment it is directly drawn into question. If the Constitution prescribes one rule and the statute another in a different rule, it is the duty of the courts to declare that the Constitution and not the statute governs in the case before them for judgment. 16 Am Jurisprudence 2D, Section 256, the general rule is that an unconstitutional statute, whether federal or state, though having of law, as in reality is in reality no law, but is wholly void and ineffective for any purposes, since unconstitutionality dates from the enactment and not merely from the date of the decision so branding it. An unconstitutional law in legal contemplation is as inoperative as though it had never been passed. Such a statute lives a question that is purports to settle. Such a statute lies a question that is purports to settle, just as it would be had the statute not ever been enacted. No repeal of an enactment is necessary, since an unconstitutional law is void. The general principles follows that it imposes no duty, converses no right, creates no office, bestows no power of authority on anyone, affords no protection, and justifies no acts performed under it. A contract which rests on a unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law. No courts are bound to enforce it. Persons convicted and fined under the statute subsequently held unconstitutional may recover the fines paid. A void act cannot be legally inconsistent with a valid one, and an unconstitutional law cannot operate to supersede an existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, it is superseded thereby. Since an unconstitutional statute cannot repeal or in any way affect an existing one, if a repealing statute is unconstitutional, the statute which it attempts to repeal remains in full force and effect, and where a statute in which it attempts to repeal remains in full force and effect, and where a clause repealing a prior law is inserted in the act, which act is unconstitutional and void, the provisions of the repeal of the prior law will usually fall with it and will not be permitted to operate as repealing such prior law. The general principles stated above applied to the Constitution as well as the law of the land, laws of the several states, insofar as they are repugnant to the Constitution and laws of the United States. 16 Am Jurisprudence 2D, Section 255, in all instances where the court exercises its power to invalidate legislation on constitutional grounds, the conflict of a statute with the Constitution must be irreconcilable. Thus, a statute is not to be declared unconstitutional unless so inconsistent with the Constitution that it cannot be enforced without a violation thereof. A clearly incompatibility between law and the Constitution must exist before the judiciary is justified holding the law unconstitutional. This principle is, of course, in line with the rule that doubts as the constitutionality should be resolved in favor of the constitutionality and the beneficiary. 16 Am Jurisprudence 2D, Section 258. On the other hand, it is clear that Congress cannot, by authorization or ratification, give the slightest effect to a state law or constitution which is in conflict with the Constitution of the United States of America. 16 Am Jurisprudence 2D, Section 260, any constitutional provision intended to confer a benefit should be liberally construed in the favor for the clearly intended and expressly designated beneficiary. Then a constitution should receive a literal interpretation in favor of a citizen in regards to a person and property. 16 Am Jurisprudence 2D, Section 552, page 460. A constitutional guarantee in the enjoyment of life, liberty, and property carries with it all the effects it shoots and renders complete the unrestrained enjoyment of that guarantee, and it has said the deprivation of anyone of those separate and independent rights may lessen or extinguish the value of the other three. 16 Am Jurisprudence, First Constitutional Law, Section 392, page 1135. Personal liberty largely consists of the right of locomotion, to go where and when one pleases, only so far restrained as the right of others may make it necessary for the welfare of all other citizens. The right of a citizen to travel upon the public highways and transport his property thereon by horse-drawn carriage, wagon, or automobile is not a mere privilege which may be permitted or prohibited at will, but the common right which he has under his rights to life, liberty, and the pursuit of happiness. Under this constitutional guarantee, one may, therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected not only in his person, but in his safe conduct. And further, personal liability consists of the power of locomotion, of changing situations, or removing one's person to whatever place one's inclination may direct, without imprisonment or restraint, unless by due process of law. Bovier's Law Dictionary, 1914 edition, Black's Law Dictionary, 5th edition, Blackstone Commentary, 134, Hare Constitution, page 777. 25, Am Jurisprudence, First Highways, section 260. In addition to the requirements that regulations governing the use of the highways must not be violative of constitutional guarantees, the prime essential of such regulations are reasonableness, impartiality, and definitiveness or certainty. 27 CFR subsection 72.11, meaning of terms. As used in this part, unless the context otherwise requires, the term shall have the meaning ascribed in this section. Words in the plural form shall include the singular, and vice versa, and words importing the masculine gender shall include the feminine. The terms includes and including do not exclude things not enumerated which are in the same general classes. ATF officer, an officer of the or employee of the Bureau of Alcohol, Tobacco, and Firearms, ATF, duly authorized to perform any functions relating to the administration or enforcement of this part. Appraised value, the value placed upon seized property or carries by the appraiser or appraisers designated for the purpose of determining whether the property or carriers may be forfeited administratively. Carrier, a vessel, vehicle, or aircraft seized under Title 49 U.S.C. Chapter 11 for having been used to transport, carry, or conceal a controlled firearm or contraband cigarettes, vessel, vehicle, or aircraft seized under other provisions of applicable laws shall be considered personal property. Commercial crimes. Any of the following types of crimes, federal or state offenses against the revenue laws, burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapon, prostitutions, including soliciting, procuring, pandering, white slaving, keeping house of ill fame, and like offenses, extortion, swindling, and confidence games, and attempting to commit conspiracy to commit, or compounding any of the foregoing crimes, addictions to narcotic drugs, and use of marijuana will be treated as if such were commercial crimes. Contraband cigarettes, any quantity of cigarettes in excess of 60,000 if A, the cigarettes bear no evidence of the payment of applicable state cigarette tax in the state where the cigarettes are found. B, the state in which the cigarettes are found requires a stamp, impression, or other identification to be placed on the package or other containers of cigarettes to evidence payment of the cigarette tax. Again, this is all about taxes, ladies and gentlemen. All right? C, the cigarettes are in the possession of any person other than any person who is, 1, holding a permit issued under Title 26 U.S.C. Chapter 52 as a manufacturer of tobacco products or as an export warehouse proprietor. 2, operating a custom-bound warehouse under Title 19 U.S.C. 1311 or 1555. 3, an agent of the tobacco product manufacturer, an export warehouse proprietor, or an operator of a custom bonded warehouse. 4, a common or contract carrier transporting the cigarettes involved under a proper bill of lading or freight bill which states the quantity, source, and destination of the cigarettes. 5, licensed or otherwise authorized by state where the cigarettes are found to account for and pay cigarette taxes imposed by that state, and who has complied with the accounting and payment requirements relating to the license or authorization with respect to the cigarettes involved. Or 6, an agent of the United States or an individual state or of a political subdivision of a state and having possession of cigarettes in connection with the performance of the official duty. 7, operating with foreign trade zones established under Title 19 U.S.C. 81B when the cigarettes involved have been entered into a foreign trade zone under zone restricted status, or when foreign cigarettes have been admitted into the foreign trade zone but have not been entered into the United States. Contraband firearm, a firearm with respect to which there has been committed a violation of a National Firearms Act, Title 26 U.S.C. Chapter 53, or any regulation issued thereunder. Director, the Director, Bureau, Alcohol, Tobacco, and Firearms, the Department of the Treasury, Washington, D.C., Equity, as used in the administrative action on petition for remission or mitigation of forfeiture, shall mean that interest which a petitioner has in the personal property or carrier petitioned for at the time of the final administration action on the petition, but such interest shall not be considered to include any unearned finance charges from the date of the seizure or the date of the default, if later any amount rebatable on account of paid insurance premiums, attorney's fees for collection, any amount identified as dealer's reserves, or any amount in the nature of the liquidated damages that may have been agreed upon by the buyer and the petitioner. Person, an individual, trust, estate, partnership, association, company, or corporation. Absolute nullity, civil law. 1. An act that is void because it is against public policy, law, or order. The nullity is non-curable. It may be invoked by any party or by the court. See LA Civ Code Article 7, 2030. 2. The state of such a nullity, Black's Law Dictionary, 8th edition, page 3391. Adams versus City of Pocatello, P-O-C-A-T-E-L-L-O. 416, page 2D, 46, or P2D, 46, 48, 91, Idaho 99. Case was had in 1966, or at least that's when the report was created. A traveler has an equal right to employ an automobile as a means of transportation and to occupy the public highways with other vehicles in common use. American Banana Co. versus United Fruit Co. 29 S period CT period 511 513 213 U period S period 347 53 L period ED period 826 19 and case 1047. The very meaning of sovereignty is that the decree of the sovereign makes law. American Mutual Liberty Inc. Institution Co. versus Chaput, C-H-A-P-U-T, 60 A period 2D 118 120 95 NH 200 Motor Vehicle 18 USC Part 1 Chapter 2 Section 31 6. Motor vehicle. The term motor vehicle means every description of a carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highway. Again, for commercial purposes on the highway. 10. The term used for commercial purposes means the carriage or person or property for any fare, fee, rate, charge, or other consideration, or directly or indirectly in connection with any business or other undertaking intended for profit. A motor vehicle or automobile for hire is a motor vehicle, other than an automobile stage used for the transportation of persons for which remuneration is received. Allen versus Newberry, 62 U.S.21 HOW period 256. The jurisdiction of the federal courts in criminal cases is expressly confined to the punishment of treason, P-I-R-A-C-I-E-S, parricide, offenses on the highway, on the high seas, offenses against the law of nations and against the postal system. U.S. Constitution, Article 1, Section 8, Article 3, Section 2. Assist versus U.S. 568 F2D 284. Not checked. A judge ceases to sit as a judicial officer because the governing principle of the administrative law provides that the courts are prohibited from substituting their evidence, testimony, records, arguments, and rationale for that of the agency. Additionally, courts are prohibited from submitting their judgment for that of the agency. Courts in administrative issues are prohibited from even listening to or hearing arguments, presentations, or rationale. ASIS versus U.S. 568 F period 2D 284. Atlas Roofing Co. versus Occupational Safety 430 U.S. 442, 1977, the Seventh Amendment does not prevent Congress from assigning to an administrative agency the task of adjudicating violations of OSHA, O-S-H-A. When Congress created the new statutory public right, it may assign their adjudication to an administrative agency with which a jury trial would be incompatible. Without violating the Seventh Amendment injunction that jury trial is to be preserved in suits at common law, that amendment was never intended to establish the jury as the exclusive mechanism for fact-finding in civil cases. So Congress could create such new public right and remedy by statute and commit their enforcement, if it chooses, to a tribunal other than a court of law, such as an administrative agency in which facts are not found by juries. Arbitrary and capricious, willful and unreasoning action without consideration and regard for facts and circumstances presented, bad faith or failure to exercise honest judgment. Black's Law Dictionary. Together, arbitrary and capricious refers to a willful and unreasonable action without consideration or in disregard of facts or the law or without determining principle. Black's Law Dictionary. Arbitrary, irrational, capricious. In term arbitrary, describing a course of action or a decision that is not based on reason or judgment, but on personal will or discretion without regard to rules or standards. An arbitrary decision is one made without regard to the facts and circumstances presented, and it connotes a disregard of the evidence. In many instances, the term implies an element of bad faith, and it may be used synonymously with tyrannical or despotic. The term arbitrary refers to a standard of review used by the courts when reviewing a variety of decisions on appeal. For example, the arbitrary and capricious standard of review is the principal standard of review used by judicial courts hearing appeals that challenge decisions issued by administrative bodies. Argosiner versus Hamlin, 407 U.S. 25, 27, 31, 37, 38, 40, June 12, 1972. Under the rules we announced today, every judge will know when the trial of a misdemeanor starts that no imprisonment may be imposed. Even though local law may permit it, unless the accused is represented by counsel, he will have a measure of the seriousness of the gravity of the offense and therefore know when to name a lawyer to represent the accused before a trial. Arthur versus Morgan, 112 U.S. 495 S 5 S period CT 241 28 L period ED 825 held that the carriages were properly classified as household effects, and we see no reason that automobiles should not be similarly disposed of. Automobile. The word automobile connotes a pleasure vehicle designed for the transportation of persons on highway. American Mutual Liberty Insurance Co. versus Caput, 60 A period 2D 118, 120, semicolon 95 NH 200. While the distinction is made clear between the two, as the courts have stated, International Motor Transit Co. versus Seattle, 251 P period 120, a motor vehicle or automobile for hire is a motor vehicle, other than an automobile stage, used for the transportation of persons for which remuneration is received. City of Dayton versus DeBrossi, 23 NE 2D 647 650 62 Ohio APP period 232. The term motor vehicle is different and broader than the word automobile. The distinction is made very clear in Title 18 USC 31. Motor vehicle means every description or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highway in the transportation of passengers or passengers and property. Used for commercial purposes means a carriage or person or property for any fare, fee, rate, charge, or other consideration, or directly or indirectly in connection with any business or any undertaking intended for profit. Bail 17C, a bond given to a court by a criminal defendant, a surety to guarantee that the defendant will duly appear in the court in the future, and if the defendant is jailed, to obtain the defendant's release from confinement. Valentine's Law Dictionary, 3rd edition, from Nexus Lexis Law Program. Right to bear arms. I write under the Second Amendment to the United States Constitution the right to bear arms as they are borne, B-O-R-N-E, by a well-regulated militia in battle, Strickland versus State, 137, Georgia, 172, S.E. 260, not a constitutional right to carry weapons on one's person as a civilian, Hill versus State, 53, Georgia, 473, 480, the same law book that is in the law library in Sweetwater County, Wyoming. Bandy versus the United States, 81, S period, CT period, 197, 198, 5, LED 2D, 218, 1960. Setting bail at an amount the defendant is unable to secure is unconstitutional if imposed to ensure the defendant will be unable to secure freedom. Bennett versus Boggs, 1 Bald W. 60. Statutes that violate the plain and obvious principles of the common right and common reason are null and void. Barney versus Board of Railroad Commissioners, 17 P. period 2D 82. The use of the highway for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and the individual cannot be rightfully deprived. Benjamin Franklin once said, "Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety." Berberrain versus Lussier, Lussier, 1958, 139, A2D, 869, 872. See also Sketcher versus Killingsworth, 380, page 2D, P2D, 136, 140, 83, Arizona, 273. This case in 1963. The right to operate a motor vehicle, an automobile, upon the public streets and highways is not a mere privilege. It is a right of liberty to enjoy, to the enjoyment of which is protected by the guarantees of the federal and state constitutions. We consider the question of whether the license to operate a motor vehicle is properly within the meaning of the constitutional prohibitions, in the case of LaPlante versus State Board of Public Roads, 47 RI 258 131 A 641, and we conclude that that a suspension of such license without prior hearing was not violative of the Due Process Clause because it was neither property nor a contract agreement. The use of an automobile as a necessary adjunct to the earning of a livelihood in modern life require us, in the highest interest of the realism, to conclude that the right to use an automobile on the public highway partakes of the nature of a liberty within the meaning of the constitutional guarantees of which the citizen may not be deprived without due process of law. In State versus Dalton, 22 RI 77 at page 86, 46A period 234 at page 237, 48L period R period A period 775, this court pointed out that the liberty which is guaranteed to every person by both our state and federal constitutions includes the right to be free from unreasonable interference in the public in the pursuit of livelihood. In the Dalton case at page 86 of 22 RI at page 237 of 46A period, quoting the People versus Gilson, 109 New York, 389 at page 399, 17 N period E period 343 at page 345, we stated, liberty in its broad sense, as understood in this country, means the right not only of freedom from servitude, imprisonment, or restraint, but the right of one to sue, but the one of right to use his faculties in all lawful ways, to live and work where he will, to earn his livelihood in any lawful calling, and to pursue any lawful trade or vocation. The Court of Appeals in Louisiana, in the case of Hughes versus Department of Public Safety, 79 SO period 2D 129, recognized that although an operator's license was not a property right, it was a right which was protected by the Due Process Clause. In that case, the court stated at page 130, a license to operate a vehicle upon a highway of the state is a privilege and not a property right, although the state may not deny this privilege to any of its citizens arbitrarily or capriciously. The proposition that a license to operate a motor vehicle and to use them on the public highways is something more than a mere privilege was also recognized in Thompson versus Smith, 155 Virginia, 367, 154 S period E period 579, 71 A period L period R period 604, and in Escobedo versus State Department of Motor Vehicles, 35 California 2D 870, 222, page 2D1. We have, however, come to the conclusion that we can no longer completely subscribe to the proposition for which the LaPlante case stands. The use of the automobile as a necessary adjunct to the earning of the livelihood in modern life requires us, in the interest of realism, to conclude that the right to the use of an automobile on the public highways partakes the nature of the liberty within the meaning of the constitutional guarantee of which the citizen may not be deprived without due process of law. In State versus Dalton, 22 RI 77 at page 86, 46 A period 234, at page 237, 48 L period R period A period 775, this court pointed out that the liberty which is guaranteed to every person by both the state and federal constitution includes the right to be free from unreasonable interference in the pursuit of livelihood. In Dalton case at page 86 of 22 RI at page 237 of 46A, quoting from People versus Gillison, 109 New York 389 at page 399, 17 N period E period 343 at page 345, we stated liberty in its broadest sense, as understood in this country, means the right not only of freedom from servitude, imprisonment, or restraint, but the right of one to use his faculties in all lawful ways, to live and work where he will, to earn his livelihood in any lawful calling, and to pursue any lawful trade or vocation. The Court of Appeals of Louisiana, in the case of Hughes versus Department of Public Safety, 79 SO2D 129, recognized that although an operator's license was not a property right, it was a right which was protected by the Due Process Clause. In that case, the court stated at page 130, a license to operate a motor vehicle upon the highway of the state is a privilege and not a property right. Although the state may not deny this privilege to any of its citizens arbitrarily or capriciously, the proposition that a license to operate a motor vehicle and to use them on the public highways is something more than a mere privilege was also recognized in Thompson versus Smith, 155 VA 367, 154 S period E period 579, 71 A period L period R period 604, and the Escobedo versus State Department of Motor Vehicles, 35 California 2D 870 222 P period 2D 1 period. Beso versus Utah Power and Light Co. 495 F period 2D 906 910. Jurisdiction can be challenged at any time, and jurisdiction once challenged cannot be assumed and must be decided. Supreme Court of the United States, number 09-1227, Carol Ann Bond, petitioner versus United States. Bond's challenge to her bond versus United States conviction and sentence satisfies the case or controversy requirements because the incarceration constitutes a concrete injury caused by the conviction and redressable by invalidation of the conviction. Spencer versus Kemna, 523 U period S period 1998, page 5. In amicus view, to argue the national government has interfered with the state sovereignty in violation of the 10th Amendment is to assert the legal right and interest of state and states alone. That, however, is not so. As explained below, Bond seeks to vindicate her own constitutional interest. The individual in a proper case can assert injury from governmental actions taken in excess of the authority that federalism defines. Her right in this regard do not belong to the state, page 8. In amicus view, to argue the national government has interfered with the state sovereignty in violation of the 10th Amendment is to assert the legal right and interest of states and states alone. That, however, is not so. As explained below, Bond seeks to vindicate her own constitutional interest. The individual in a proper case can assert injury from governmental actions taken in excess of the authority that federalism defines. Her rights in this regard do not belong to the state. Page 8. Good gravy. The former concluded that allocation of powers between the national government and the states enhances freedom, first by protecting the integrity of the governments themselves, and second by protecting the people, from whom all governments' power are derived. Bond versus U.S. SCOTUS recognized personal sovereignty, June 16, 2011, on page 8. Federalism secure the freedom of the individual. Federalism also protects the liberty of all persons within a state by ensuring that the laws enacted in excess of delegated governmental power cannot direct or control their actions. See IBID. By denying anyone governmental complete jurisdiction over all the concerns of public life, federalism protects the liberty of the individual from arbitrary power when government acts in excess of its laws, of its lawful powers. That liberty is at stake. The limitation that federalism entails are not therefore a matter of right belonging to only to the states. States are not the sole intended beneficiary of federalism. See New York Supra at 181. An individual has a direct interest in objecting to laws that upset the constitutional balance between the national government and states when the enforcement of those laws causes injury that is concrete, particular, and redressable. Fidelity to principles of federalism is not for states alone to vindicate. The recognition of an injured person standing to object to a violation of a constitutional constitutional principle that allocates power within government is illustrated in an analogous context by cases in which individuals sustain discrete justicable injury from actions that transgress separation of powers limitations. Separation of powers principles are intended in part to protect the each branch of government from incursion by the other. Just as it is appropriate for an individual in a proper case to invoke separation of powers or check and balances constraints, so too may a litigant in proper cases challenge a law as enacted contravention of constitutional principles of federalism. That claim need not depend on the veracious assertion of a state's constitutional interest, even if a state's constitutional interest are so implicated. The principle of limited national government powers, the principle of limited national powers and state sovereignty are intertwined. While neither originates in the 10th Amendment, both are expressed by it. Impermissible interference with state sovereignty is not within the enumerated power of national government. See New York 505 U.S. at 155 through 159, and actions that exceed the national government and enumerated powers undermines the sovereign interest of the state. See United States versus Lopez, 514 U.S. 549, 561, 1995. The constitutional action can cause concomitant injury to persons in individual cases. Justice Ginsburg, with whom Justice Breyer joins, concurring, I join the court's opinion in writing separately to make the following observation: bound like any other defendant, has a personal right not to be convicted under the constitutionally invalid law. Bonds versus U.S., volume 131, 529, U.S., delegates of the First Federal Convention prohibited the use of corporations by all governments representing the American Republic. Therefore, all of these corporate governments and their corporate laws or usurpation of the organic Constitution of the United States of America, all state governments are subcorporations of the federal government, making all courts and law enforcement personnel a corporate employee. See James Madison Journal Convention, volume 28,722. Bonds versus U.S., volume 131, 529, U.S., page 334, 2000, CIT 761, volume 131, page 39. Bonds versus Smith, 430 U.S. 817, 1977, syllabus. The fundamental constitutional right of access to the courts held to require prison authorities to assist inmates in the preparation and filing of meaningful legal papers by providing prisoners with adequate law libraries or adequate assistance from persons trained in the law. Younger versus Gilmore, 404 U.S. 15, page 430 U.S. PP period, 430 U.S. 821 through 833. Boyd versus United States, 116 U.S. 616, 1886, in order to ascertain the nature of the proceedings intended by the Fourth Amendment to the Constitution under the terms unreasonable searches and seizures, it is only necessary to page 116 U.S. page 116 U.S. 625. Recall the contemporary or then recent history of the contrivancy on the subject, both in this country and in England. The practice had obtained in the colonies of issuing writs of assistance to the revenue officers, empowering them in their discretion to search suspected places for smuggled goods, with James Otis pronounced the worst instrument of arbitrary power, the most destructive of English liberty, and the fundamental principle of law that ever was found in an English law book, since they place the liberty of every man in the hands of every petty officer. Footnote 3. This was in February 1761 in Boston, and the famous debate in which it occurred was perhaps the most prominent event which inaugurated the resistance of the colonies to the oppression of the mother country. Then and there, said John Adams, then and there was the first sense of the first act of opposition to the arbitrary claims of Great Britain. Then and there, the child of independence was born. Boyd versus the United States, 116 USR 616. The court is to protect against encroachment of unconstitutionality or secured liberty. It is equivalent to the compulsory production of papers to make the non-production of them a confession of the allegation which is pretended they will prove. The seizure of compensatory production of a man's private paper to be used in evidence against him is equivalent to compelling him to be a witness against himself. Violation of the Fifth Amendment, and in a prosecution for a crime, penalty or forfeiture is equally within the prohibition of the Fifth Amendment. Boyd versus the United States, 116 U.S. 616, 1886. This can only be obviated by adhering to the rule that constitutional provisions for the security of persons and property should be liberally construed. A close and literal construction deprives them of half their efficiency, and leads to gradual depreciation of the right, as it consists more in sound than in substance. It is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachment thereon. Boyd versus the United States, 116 U.S. 616 through 635, Supreme Court case, 1886. It may be that it is the obnoxious thing in its mildest and least repulsive form, but illegitimate and unconstitutional practices get their first footing in that way, namely by silent approaches and slight deviations from legal modes and procedures. This can only be obviated by adhering to the rule that constitutional provisions for the security of person and property should be liberally construed. A close and literal construction deprives them of half their efficiency and leads to the gradual depreciation of the right, as if it consisted more in sound than in substance. It is the duty of the courts to be watchful for the constitutional rights of the citizens and against any stealthy encroachment thereupon. Brinkman versus Pachokalike, Pacholike. 84, in period, E period, 672, 764, 41, IND period, APP period, 662, 666. The law does not denounce motor carriage as such on public ways, they have an equal right with other vehicles in common use to occupy the streets and roads. It is improper to say that the driver of those horses has rights in the road superior to the driver of an automobile. Both have the right to use the easement. Belova Watch Co. versus Zales Jewelry Co. However, at 84 P period 2D 771, the opinion takes issue with the philosophy that the legislator may forbid or restrict any business it has a sufficient force of public opinion behind it, calling attention to Article 1, Subsection 7, Wyoming Constitution, which says, absolute arbitrary power over the lives, liberty, and property of a free man exists nowhere in a republic, not even in the largest majority. Article 1, Section 6, Wyoming Constitution requires the lawful process be employed before a person is deprived of life, liberty, and property. The liberty envisioned is not alone a liberty of person such as is offered by enslavement, imprisonment, or other restraint. It contemplates a person's liberty to do all that is not made unlawful. Hence, persons are at liberty to make any lawful contracts. Equal persons are at liberty to refrain from making contracts, and a prime requisite of contract obligation is that the undertaking is voluntarily assumed and not occasioned by fraud, duress, or any form of compulsion, governmental as well as private. Voluntary engagement by contract entails the contractual assumption of a binding obligation as opposed to an obligation imposed by law. A legislative act which purports to burden a person with a contractual covenant agreed to by private parties or private interests, but not agreed to by the non-signing retailer, violates that person's liberty not to so contract if he elects and robs that person of his liberty without due process. The legislator may not impress contractual duties which have been voluntarily assumed by others as the contractual duty of a person not a party to such contracts. This is more especially true where the terms of the contracts are ordained and directed by the selfish interest of private persons, primarily for their benefit, and are adverse and antagonistic to the interest and desire of the non-signer, who is here sought to be controlled against his will. Article 1, Section 37, Wyoming Constitution recognizes federal Constitution as the supreme law of the land. Its contingency in this case is found in the due process provision of the 14th Amendment, which it will not be necessary to separately discuss. Article 2, Section 1, Wyoming Constitution vests the state government in three distinct departments: the legislative, executive, and judicial. This need no present commitment, as the legislative function will be dealt with in the following. Article 3, Section 1, Wyoming Constitution vests legislative power in the state's legislature. This provision is invoked under the claim that the act is unlawful delegation to private parties of that legislative power and without any safeguards for the protection of the public. Even though the legislator be empowered to impress merchandising with a limitation intended to prevent discrimination and tortious competition, such a power can only be exercised by the legislator itself. We have found no better way to condemn such legislation than the words of the court in Yick Woo versus Hopkins, 118 U.S. 356 370 S.6 S.CT 1064 1071 30 L.ED 220. The very idea that any one man may be compelled to hold his life or the means of living or any material right essential to the enjoyment of life at the mere will of another seems to be intolerable in any country where freedom prevails, as being the essence of slavery itself. This pronouncement was quoted in State versus Langley, 53 Wyoming, 332, 84 P. 2D 767, 776, in support of its holding in that case, and was used in the Nebraska decision in State versus Drayton, 82 Nebraska, 254, 117, W. 768, 223, L. R. A. comma, in period, S period, comma, 1287, comma, 1:30 a.m., period, ST, period, report, period, 671, and quoted approvingly in Powell versus Pennsylvania, 127 U.S., 678, 685, 8, S period, CT period, 992, comma, 996, comma, 32, L period, ED period, 253. While in the State versus Langley Supra, where the above statement was used by our court, the constitutionality of our anti-discrimination law was upheld. The force of the statement is enacted because it is a two-edged sword that cuts both ways. On the one hand, to uphold the constitutionality of good law, but to strike down as unconstitutional bad law. We will not and we do not substitute our opinions in such matters for the consideration judgment of our lawmakers. Yet, we ourselves have a function to perform, a constitutional right and the paramount duty to insist that the legislature not renounce its legislation power by any such attempt to delegate it away. We approach the limit of judicial tolerance in upholding legislative fiat in the so-called trading stamp matter. Steffi versus City of Casper, Wyoming, 357 P period 2D 456, 1960, rehearing 358 P2D 951 in 1961. Byers versus United States, 273 U.S. 28, 1927. 2. Evidence of a crime discovered by a federal officer in making search without lawful warrant may not be used against the victim of the unlawful search where a timely challenge has been interposed. P period 273 U period S period 29. 3. Constitutional provisions for the security of persons and property are to be liberally construed, and it is the duty of the courts to be watchful for the constitutional rights of the citizen and against the stealthy encroachment thereupon. P period 273 U.S. period U period S period 32. Kahua versus United States, 152 U period S period 211, 1894. For the word action may include both civil and criminal proceedings. The laws of Congress in respect to those matters do not extend into the territorial limitations of the state, but have force only in the District of Columbia and other places that are within the exclusive jurisdiction of the national government. California statutes at large, California Chapter 412, page 83, highways are for the use of the traveling public, and all have the right to use them in a reasonable and proper manner. The use thereof is an inalienable right of every citizen. Escabode versus State 35 C2D 870 in 8 California Jur 3D P27. Right, a legal right. A constitutional right means a right protected by the law, by the Constitution, but government does not create the idea of right or original rights. It acknowledges them. Bouvier's Law Dictionary 914, page 2961, those who have the right to do something cannot be licensed for what they already have right to do. As such, license would be meaningless. California Statute at Large, California, Chapter 412, page 83, highways are for the use of the traveling public, and all have the right to use them in a reasonable and proper manner. The use thereof is an unalienable right of every citizen. Escabode versus State 35 C2D 870 and 8 Cal Jur 3D P period 27. Right and legal right. A constitutional right means a right protected by the law, by the Constitution, but government does not create the idea of rights or original rights. It acknowledges them. Bouvier's Law Dictionary 914, page 2961. Those who have the right to do something cannot be licensed for what they already have the right to do. As such, licenses would be meaningless. California Motor Transportation Code versus Trucking Unlimited, 404 U.S. 908, 1972. What is prohibited to the state is forbidden to the courts to enforce. Campbell versus Walker, 78 ATL period 601, 603, 2 Boyce, Dell, 41. The owner of an automobile has the same right as to the owner of other vehicles to the use of the highway. A traveler on foot has the same right to the use of the public highways as an automobile or any other vehicle. Kanisha Kenesha Mills versus DC 209, the use of an automobile as a necessary adjunct to the earning of a livelihood in modern life requires us, in the interest of the realism, to conclude that the right to use an automobile on the public highways partakes of the nature of a liberty within the meaning of the constitutional guarantees. It cannot be gainsaid that citizens have a right to drive upon the public streets of the District of Columbia or any other city, absent a constitutionally sound reason for limiting their access. It has long been established that the loss of constitutional freedom for even minimal periods of time unquestionably constitutes irreparable injury. Elrod versus Burns, 427, U.S. 347, 373, 1976. Plurality opinion citing New York Times Co. versus United States, 403 U.S. 713, 1971. Case law, which is really case precedent. Ugh, I fucking hate that word. The following rulings state this applies to the instant case Miller versus Dury, 1T1 U.S. 7 Cranch 481 1813. The United States Supreme Court ruled that the merits of the case, as settled by the courts of one state, must be recognized by the courts of other states. State courts may not reopen cases which have been conclusively decided by the courts of another state. Later Chief Justice John Marshall suggested that the judgment of one state court must be recognized by other state courts as final. Also, Abelman versus Booth, 62 U.S. 503, where the higher court stated that the lower courts were bound by all federal court rulings, as well as Howlett versus Rose, 496 U.S. 356 in 1990. Federal law and Supreme Court cases apply to state court cases. Cooper versus Aaron, 358 U.S. 1, 1958. States are bound by the United States Supreme Court case decisions. Also, Article 4 of the U.S. Constitution states that each state shall give full faith and credit to the other states' laws. This would include case law, except for there's no such fucking thing as case law. How do we overcome that insanity? And it's time for me to have a smoke break. I'll come back. This thing is 95 pages. And some of it seems to be contradictory, but I can assure you it's not. It's in the context and the form and the jurisdiction of the language and the words that are used. So when it's saying that driving is a privilege, it's absolutely a privilege. To engage in commerce in the commercial sector is a privilege, and it's a privilege that is licensed. However, in the constitutional aspect of things, ladies and gentlemen, you have a right to a living. You can go out there and do whatever you want so long as your activity doesn't encroach upon the rights and the liberties and the freedoms of others, all right? So there are two separate, distinct jurisdictions. There's one that pertains to the federal enclaves, Title 28, 3002, 15A, Guam, Puerto Rico, the Mariana Islands, the Swanee Islands, or Swain Islands, I think is how they're pronounced, and the territories thereof. And then there's the other side of that spectrum, okay? It's like using a prism to see the colors that are within the light, all right? And they're very separate and they're very distinct. And so when you understand how these jurisdictions work, you can start to see them by the words that are being used, all right? The right to travel is an unalienable right. No man can be tied by any form of legislation that would prohibit him from engaging in that activity, because it would be an absolute atrocity. It would be an egregious action to allow that what man created to govern man in such a fashion. Again, government was not instituted amongst men to govern men. Government was instituted amongst men to protect man's property and rights from overzealous corporations encroaching upon it as they grew bigger, because we were a capitalist nation, okay? So naturally, when capitalism takes off and a few people become extraordinarily wealthy, they can start to manipulate situations, which is exactly what you've seen with the Rothschilds. It's exactly what you've seen with J.P. Morgan and all these puppets. Not knocking capitalism. These people were genius, but then they found a way to use it to subvert from the Constitution pay lobbyists to basically buy your Congress and your legislative branch and your judiciary to rule in their favor, okay? So they can capitalize on gains and destroy the earth and everything else that they're about. And in hindsight, when you really think about it, what are they doing? They're destroying the earth. They're destroying your rights. They're destroying the core values of the greatest experiment the world has ever seen, a free society, right? Based upon hypothetical numbers punched into a computer, a bunch of ones and fucking zeros, people. If that doesn't grab you by your balls and just piss you off, if that don't, like somebody pulling a hair right from your taint, if that don't just chap your ass, I don't know what the fuck will. I don't know what the fuck does, all right? But the importance of this is to see the distinguishing differences between the jurisdictions and to give you hope and to give you the spirit of fighting. Put on your fucking gloves, put up your hands, clench your fists, get ready for it. Let's get it on, all right? But let's be prepared with the knowledge to do it, all right? That's why myself and so many other people I talk to go into courts and spank the shit out of judges who want to arbitrarily subvert from the Constitution to enforce some public fucking policy so they can unjustly enrich themselves, okay, by monetizing and utilizing securities and our ignorance, okay? And then when they get somebody that's intelligent in there, instead of being, you know, cautious or erring on the side of cautious, they got too many people in the fucking peanut gallery, you see? Can't let the cat out of the bag, so then they decide to be assholes about it and be stupid. Take him out of the court. We'll save him for last, because I'm the judge. You know, right? When you see those things, if you're ever in a court and you see a man get ushered out and you hear any of those fucking administrators saying, we're saving him for last, go pop a bag of popcorn, grab yourself a soda, and come back into the court and sit down and wait for that motherfucker to come back. Because I guarantee you're about to see a show. Right, wrong, or any different, whether he prevails or he doesn't prevail. At least once in your life, you got to see a man stand up for your fucking rights and for his, okay? Because it's a dangerous, precarious position to be in those courts. Because again, they have gun-toting morons with the IQ of 70. They go, I just do what I'm told by the judge. That's not your fucking job there, Shotsky. You're supposed to uphold the Constitution. You're supposed to know more about the law than I do. And when the judge egregiously encroaches upon my rights, you're supposed to tell that son of a bitch one more step, Your Honor, and I will cuff and stuff your ass like